Hello, my dear students. Welcome to HM Commerce Education. This is CA Mani Chandana, right? We've completed with Memorandum of Association, and now we'll have to start off with Doctrine of Ultravires, right? So, without wasting time, let's jump into the topic, right? Doctrine of Ultravires. What is this? Doctrine of Ultravires. Children, have you ever heard this word doctrine? Doctrine. What do you mean by doctrine? Doctrine meaning principle. It means principle. Let me write it down here. Doctrine of ultra wires. Yes. What do you mean by doctrine? Doctrine meaning principle. Yes. And ultra wires. What do you mean by ultra wires? We've already learned. Yes. What do you mean by it? Beyond its powers. Beyond its powers. Yes. Right. About what are we talking about? We are talking about a principle. Principle doctrine of ultravires. Quite important. Okay. It's very easy, but now what do you mean by this? What do you mean by this particular principle? Right? Okay. So see, any act done or a contract made, okay, which is beyond the powers of the company, which is beyond the powers of the company, is void ab initio, is void ab initio. Yes, it is not binding on the company. It is not binding on the company. Not binding on the company. Yes, also company can neither sue nor be sued for such acts. Such acts meaning ultravires act, beyond whatever acts it has done which is beyond its powers. Beyond its powers meaning which is not authorized, which is not authorized by its MOA, right? It is not authorized by its MOA. Where the objects clause? You all know, right? The objects clause. Correct? So if any act is made by a company, or if a contract is entered into by a company which is beyond the powers of the company. Yes, say for example, I took an example of real estate company, right, in the afternoon, whenever we in the previous class. So what did I tell? If that particular company which is into real estate, to to enter into joint ventures, to purchase lands, to build to build a building, etc. So if this company, if it enters into a contract outside the scope of its business, outside the objects or outside the powers which has been granted by the objects clause of its memorandum of association, that will be called ultravires to the company. That will be called ultravires. It is void ab initio. That particular transaction which the company has entered into will be void ab initio, and it will not be binding on the company. Say for example, if that real estate company enters into a contract to supply, say, computers, or say it enters into contract with some other company, to a third party to sell mobile phones, whether this act or whether this contract of this particular real estate company to sell mobile phones or to sell laptops, is it binding on the company? No, it is not binding on the company. Why? Because it is beyond the powers of the company. Yes, Then whether the company can neither sue or nor be sued for such acts. It cannot go to court of law. Neither the other party, the third party, cannot sue against this particular company. Getting it? Yes, simple, very simple. Yes or no, children? Yes. Okay. Yeah. See, when we talk about ultra wires beyond its powers, we usually talk about what? The objects clause, the power granted to it in the objects clause of the memorandum. This is what we talk, right? But this ultra wires beyond its powers can be, yes, I'll just write it down so that you will understand it better. Okay, see, this ultra wires an act can be ultra wires the MOA. Ultra wires the MOA. It can be ultra wires the AOA, right? It can be ultra wires the directors. Basically, directors also, the powers granted to the directors. Okay, let me make a simple chart for you so that it will be even more easier for you all to understand this particular topic. Okay, yeah. Okay, see, when an act is performed, which is not authorized, by MOA, that is objects clause. Yes or no? That is objects clause, right? This is ultra wires the company. This is called this is ultra wires the company. Tell me whether this is valid. No, ma'am, this is not valid. This is void. This is void ab initio. This is void ab initio. It cannot be ratified. It cannot. It cannot be ratified. What do you mean by ratified? Ratified meaning made good. Yes, ratified meaning made good. If it is void, making it valid. Void contract to valid contract. It can ratified even. It cannot be ratified even by the unanimous consent. Even by the unanimous consent of all the shareholders. Yes. What do you mean by unanimous consent? What do you mean by unanimous? Meaning all of them agree, all of the shareholders agreeing to this particular whatever the we are talking about, right? So it cannot be ratified even by the unanimous consent of all the shareholders. It cannot be ratified. Okay. Next, let's come to the next act, that is when an act is performed, which is ultra wires, the directors, which is ultra wires the powers of the directors, which is ultra wires the powers, we will write powers of directors, but intra wires. But now what is intra wires? Intra wires meaning within the powers. Yes, ultra wires is beyond the powers, intra wires is within the powers. But intra wires the company. But intra wires the company. What is the legal effect, ma'am? See, if it is ratified, if it is ratified by the company, by the members of the company, by a resolution, by a resolution passed at general meeting, it is valid. Okay, we will learn. Okay, I will teach you everything in detail, don't worry. Okay, next an act which is okay, we will write which is act which is within the powers of the company, within the powers of the company, but done irregularly, right? What is the effect? What is the effect? Shareholders can ratify it. Shareholders can ratify the same. Okay. Next, the last one. Okay. Okay. The act is Ultravires, the AOA. AOA meaning Articles of Association. Yes, what is the legal effect? It can be ratified by amending or altering the AOA, bypassing special resolution at general meeting. Ma'am, you've written so much, we haven't understood anything. We've written so much, but we haven't understood anything. It's okay, children. We will look into it in detail. Okay. So, see, the first concept here, when an act is performed which is not authorized by the Memorandum of Association, is Ultravires the company. It is void ab initio and it cannot be ratified even by the unanimous consent of all the shareholders. Ma'am, example. Say, as I told you, say for example, there is one company called ABC Limited. This particular company is, say, involved in trading, in manufacturing and trading of electric items. Is involved in manufacturing and trading of electronic items. Okay. Say, for example, TV, fridge, all of these. Now, it enters into a contract. Suddenly, it enters into a contract to, say, for example, to sell these water bottles, to sell these steel water bottles. You know these flasks and all these steel water bottles, Milton, not Milton. Okay, fine. Yeah, to sell these water bottles. Now, tell me whether it is authorized to do so, whether it has power to enter into such contracts of selling those water bottles. No, what is its powers? Obviously, to sell electronic items. Say, for example, those ovens, or say those chimneys, or say, for example, TVs or fridge, etc., etc. This has entered into a contract to sell water bottles. Okay. Does this have power? Does it have power? No, it does not have power. So, if it enters into a contract to sell such water bottles, obviously that particular contract is void ab initio, does not have any legal effect. Yes, obviously the other person cannot sue this company, or this company cannot sue the other party, because it does not have any legal effect, because it is Ultravires the memorandum of the company. Getting it? It cannot be ratified. This act cannot be ratified even by the unanimous consent of all the shareholders. Getting it? Easy. Yes, ma'am, easy. Okay, you also can take the example of that real estate company entering into sale of laptops or entering into sale of mobile phones. Getting it? Yes, yes or no? Yes, ma'am. Okay, next, when an act is performed which is ultravires the powers of directors but intravires the company, which is ultravires the powers of the director. So, say for example, there is we will take an example wherein, okay, a company has power in its in its documents to say to raise a loan of up to say 100 lakhs, up to loan of 100 lakhs. Okay, this is the company's power. Okay, Now, but one individual director, what's wrong with this pen today? Pen or stylus or whatever you say. Okay. Yeah. One individual director, yes, has power only to raise, say for example, 60 lakhs. For example, 60 lakhs, right? What is the power of the individual director? The individual director has the power to raise loan. I'm talking about loan of up to 60 lakh. He only has so much of power. He has power to raise only 60 lakhs loan. But the company has power to raise up to 100 lakhs. Yes, what did this director do? He went on to raise, say for example, 75 lakhs. He went on to raise, say for example, 75 lakhs individually in with sorry. So this individual went on to raise how much? Rupees 75 lakhs. Is it within his power? Is it within his powers? No, it is not within his powers. But is it within the powers of the company? Is this 75 lakhs will within the powers of the company? Yes, obviously, because the company has the power to raise up to 100 lakhs of loan. Ma'am, is this valid? Can the director do so? Obviously, the director cannot do so. But in exceptional cases, if it was like if it is a bona fide case, then obviously if the members understand it was necessary to do so, then these members of the company will ratify the act of the director by passing a resolution at the general meeting. So in the shareholders general meeting, they will ratify the act of the director. Getting it? Easy, right? Yes. Okay, next, let's come to the next. When an act is performed which is within the powers of the company, but done irregularly, Now, what is this? Give us an example. Okay. So let's take an example of one company. Okay. Say for example, ABC Limited. Okay. ABC Limited. Okay. It can basically it is involved in some manufacturing business. Okay. Manufacturing of say mobile phones. Okay. Involved in manufacturing of mobile phones. Now, for it to purchase the raw materials from its supplier, it can say for example it needs the permission of purchase manager. Okay. If the value of purchases if the value of purchases exceeds say 50 lakh, so what did I tell? There is a company ABC Limited, and it is involved in manufacturing of some mobile phones, and for purchase of its raw materials, if the value exceeds 50 lakhs, there is certain condition that the purchase manager must agree, must give his consent to. Now, what happened without taking the permission of this purchase manager? An order of say for example 60 lakh was made with the supplier. Okay. Is this within the powers of the company? Yes, obviously, purchase of raw materials for manufacturing of the mobile phone, say for example, battery or some lens or whatever it is. It has made an order. So, is it within the powers of the company? Yes, it is within the powers of the company because it manufactures mobile phones. Now, this has some irregularity. What is that? Did the permission of the purchase manager was being taken? No, it was not being taken. So, there is some irregularity. Now, this can be ratified by the shareholders. This thing, if it is bona fide, if it was necessary at that particular case, the shareholders can ratify it. It is valid. It will be valid. Getting it? It is within the powers of the company, but it is done irregularly. So, shareholders can ratify it and it is valid. Yes. Understood? Yes, ma'am. Okay. Now, then next, the last one. Okay. Okay. Then the last one, when an act is performed which is ultravires the AOA, which is ultravires the AOA. What is Articles of Association? Articles of Association is nothing but the company's rules and regulations for controlling its internal affairs. For controlling its internal affairs, these are the rules and regulations. Okay. So this, if there is an act which is ultravires the Articles of Association, it can be ratified by altering the Articles of Association. It is valid. It is valid by passing a special resolution at the general meeting. By passing a special resolution at the general meeting, right? Getting it? Yes, yes or no? So basically, it is not ultravires the powers of the company. It is not ultravires the MOA. It is ultravires the AOA. It can still be ratified. It can still be ratified by altering the MOA by passing a special resolution at the general meeting. Right? Clear, everyone? Yes? Yes, ma'am. Okay, fine. So if you are done with this, just take a screenshot of this. Yes, of this Doctrine of Ultravires. And you have done with this, take a screenshot of this as well. Okay, right? Okay, if you're done, let me go to your textbooks. Okay, fine. So Doctrine of Ultravires, right? The meaning of the term ultravires is simply beyond its powers, beyond their powers. Good. The legal phrase ultravires is applicable only to acts done in excess of the legal powers of the doers. Doers can be anyone. It can be the directors, it can be the company, right? Okay, done in excess of the legal powers. Whatever it is in excess, for that we call it ultravires. It is applicable only to the acts done in excess of the legal powers of the doers. This presupposes that the powers in their nature are limited. Fine. It is a fundamental rule of the company law that the objects of a company, as stated in its memorandum, can be departed from only to the extent which is permitted by the Act, thus far and no further. Whatever it is permitted, how much ever is permitted by the Act, only so much it can depart from the objects of the company and not further. In consequence, any act done or a contract made by the company which travels beyond the powers of the company, beyond the powers not only of the directors but also of the company. If it is of the directors, it can be ratified, yes or no? But if it is of the company, can it be ratified? No, it is wholly void and it is inoperative in law. It is void. It does not have any legal effect in law, and therefore it is not binding on the company. Therefore, it is not binding on the company. Correct? Yes, ma'am. On this account, a company can be restrained from employing its funds for purposes other than those sanctioned by the memorandum. Likewise, it can be restrained from carrying on a trade different from that from the one it is authorized to carry on. Obviously, the company can be restrained. Restrained meaning what? To be controlled. The company can control from employing its funds. Its funds meaning the business funds, the company's funds, for purposes other than those sanctioned in the memorandum. Whatever it basically meaning, it can employ its funds only for the powers or only for the objects in the memorandum. Other than those, it cannot employ its funds. Also, for carrying on a trade which is different from the one which is authorized in its memorandum. It has to carry on only those which are stated in the memorandum. Anything else, it is restrained. Anything else which is not given in the memorandum of association, it is restrained from doing so. Clear? Yes, ma'am. Okay, the impact of Doctrine of Ultravires is that a company can neither be sued on an ultravires transaction nor can it sue on it. It cannot be sued. It cannot be sued nor it can sue the other party. Since the memorandum is a public document, it is open to the public inspection. Since this is a public document, we all know that memorandum is a public document. Yes or no? It is open to public inspection. Therefore, when one deals with a company, one is deemed to know about the powers of the company. If in spite of this you enter into a transaction which is ultravires the company, you cannot enforce it against the company. Say for example, a company is into manufacturing and selling of mobile phones, and this company enters into some finance activity, enters into activity of giving loans to the third parties. Yes, is this and if the company promises, for example, I am a company, I am into manufacturing and selling of mobile phones. I promise a third party that I will be giving giving, say for example, 50 lakhs loans. So this is nothing but a finance activity. Lending of loans is related to finance activity, right? And that third party relies on me. He does not see the memorandum of the of mine, meaning the company, right? Still he says he enters into contract that he will accept the loan, and I will give a loan. He relies on me, and finally what I'll do, I'll not give him loan. Can he go to court of law? Can he go to court of law? No, he cannot. He cannot. Can he tell me, I have relied on your money, please, I want to give you, I want to start some business, I have relied, I thought that you will give me 50 lakh loans, I relied on you, now if you cannot give me loan, I cannot start my business. Not my problem. Yes or no? Getting it? Yes. So he had to read my MOA. Yes or no? Because that's a public document. Correct. Yes. Yes, ma'am. Therefore, when one deals with a company, one is deemed to know about the powers of the company. If in spite of this, you enter into a transaction which is ultravires the company, you cannot enforce it against the company. Yes. Yes, ma'am. Since the memorandum is a public document, it is open to see. Since the memorandum is a public document, one second. Okay, let me try. Okay, since the memorandum is a public document, it is open to public inspection. When one deals with a company, one is deemed to know about the powers of the company, whether the company has power to lend loans, or whether whether the company has power to sell so and so product. The other person has to know, because this is a public document. If in spite of this you enter into a transaction which is ultravires the company, you cannot enforce it against the company. Clear? Everyone is clear? Yes, ma'am. Right. Very good. Next, example 7. Example 7. Okay, what are we talking here? Fine. If you have supplied goods or performed service, if you have supplied goods or performed service, let me just check if it's recording. Yeah. If you have supplied goods or performed service on such a contract meaning an ultravires contract or lent money, you cannot obtain payment or recover the money lent. But if the money advanced to the company has not been expended, the lender may stop the company from parting with it by means of an injunction. Okay, let's just take few examples. So yes, we were discussing about example 7. So where I told you there is one company, ABC Limited, right, which is involved in manufacturing and supply of electronic items, right? So there is one person, third party, Mr. X, okay, and this person has agreed to supply, say for example, 1000 lipsticks. What? 1000 lipsticks. Yes. Now, this person, the third party, had to read the memorandum of association. He had to know that this particular company is involved in trading of electronic items. If he has agreed to sell 1000 lipsticks to this particular company, and if he is expecting that company to pay him money, who's going to save him? Tell me, who is going to save him? No one. Getting it? Yes or no? Say in the similar manner, say again ABC Limited, okay, ABC Limited, and there is one more, the other person, say for example, Mr. Y. Mr. Y, he has lent, say for example, lent 5 lakh rupees. Lent 5 lakh rupees. Now, this particular company, ABC Limited, does not have power. does not have power. It is beyond its power. This person has lent rupees 5 lakh. Now see, what are they trying to tell? If you have supplied goods or performed service on such contract or lent money, you have lent money. Yes, you have lent money. You cannot obtain payment. You cannot ask for this. Say for example, say 1,000 lipsticks into 100 rupees, say 1 lakh. Say 1 lakh rupees. You cannot recover that particular amount from the company or recover the money lent. You have lent rupees 5 lakh. You cannot recover that particular money, whatever you have lent. If it is ultravires, the company. But if the money advanced to the company has not been expended, whatever you have lent, say for example 5 lakh rupees, that has not been expended, meaning the company has not expended it, meaning it has not used it, right? It has not expended, the lender may stop the company from parting with it by means of an injunction. Say for example, this 5 lakh, the company has not expended. Company has not expended. Yes. So what can you do? You can bring in an injunction order, meaning a stay order. Injunction order for what? To stop. Injunction order meaning a court order. Okay, to stop the company from parting with it, from using that particular amount. Yes, getting my point? Yes. Okay, this is because the company does not become the owner of the money, which is ultravires. Obviously, when the company does not become the owner of that particular amount, whatever you have lent it to that particular company, so you can go to the court of law. You can go to the court of law and bring in an injunction order, meaning stay order, or basically a court order from stopping that particular company to part away from that money. Getting it clear? Yes, ma'am. As the lender remains the owner, who is the lender here? Mr. Y remains the owner. He can take back the property in specie, meaning in real. So because he is the actual owner and the company is not the actual owner of that particular rupees 5 lakh, or be it these 1,000 lipstick, he can go to the court of law and he can stop the company from parting away with it. And because this Mr. Y is the real owner, he can take back the property. Property in this rupees could be this rupees or could be this 1,000 lipsticks. Okay. If the ultravires loan has been utilized in meeting lawful debt of the company, then the lender steps into the shoes of the debtor paid off, and consequently he would be entitled to recover his loan to the extent from the company. Ma'am, what is this? We did not understand. What is this particular line. Children, let me explain it to you. Okay. Say for example, this Mr. Y. Okay, there is this ABC Limited, right? ABC Limited. In the balance sheet of ABC Limited, there is a loan. There is a loan from, say, P. There is a loan from P. There is one person P. Okay, say for example of 15 lakhs. Of 15 lakhs. In the books of the ABC Limited, there is a loan which is taken from Mr. P of rupees 15 lakh. Now what happened? This company received rupees 5 lakh from Mr. Y. Yes. Now it used this rupees 5 lakh to pay off this to pay off this loan which is taken from P. So minus 5 lakh. It paid off a debt, paid off a loan. Yes or no? This particular ABC Limited, it took money from Mr. Y and it paid off its loan, lawful debt, which one? 15 lakh. This is a loan which is taken from P. This particular ABC Limited paid off rupees 5 lakh to Mr. P. Now, see what will happen. If this ultravire loan has been utilized in meeting lawful debt of the company, then the lender, who is the lender now? Lender is Mr. Y. Mr. Y will step into the shoes of P. Meaning he will step into the shoes of P, meaning obviously he will act as P. meaning step into the shoes of P, and he will be able to recover this amount of 5 lakh from ABC Limited. He will be able to, as though he is P, as though he is P, he will be able to recover back this amount of rupees 5 lakh from the company. Getting my point? Yes or no? Yes. See, now again we will read the entire example from first. I'm so sorry for this pen issue. Okay, the stylus issue. I think there was some disturbance, but still I think the concept is clear. See, if you have supplied goods or performed service on such a contract, meaning which is a ultravires contract, or lent money, you cannot obtain payment or recover the money lent. Yes, but if the money advanced to the company has not been expended, the lender may stop the company from parting it by means of an injunction order. Okay, by means of a court order. Okay, this is because the company does not become the owner of the company, obviously, because it is a ultravires to the company. Yes, as the lender remains the owner, he can take back the property in real. Yes, if the ultravires loan has been utilized to meeting a lawful debt of the company. Lawful debt of the company. Company had a loan of 15 lakhs. The amount which the company received from Mr. Y, it utilized to pay off the lawful debt from taken from Mr. P. Now, the lender, who is the lender? Mr. Y. This lender steps into the shoes of the debtor paid off. Who is the debtor paid off? P. Yes or no? And consequently, he would be entitled to recover his loan to that extent from the company. From the company. Simple. Yes. Yes, ma'am. Okay. Next, an act which is ultravires the company being void cannot be ratified by the shareholders of the company. You know. Yes. Next, sometimes act which is ultravires can be regularized by ratifying it subsequently. I have also given you the example. Yes. Yes, ma'am. Okay, fine. See, for instance, if the act is ultravires the powers of the directors, the shareholders can ratify it. If it is ultravires the articles of the company can alter the articles. If the act is within the power of the company, but it is done irregularly, the shareholders can validate it. They're just giving an example. Okay, good. Understood? Yes, ma'am. Okay, next, the leading case through which the doctrine was enhanced. Okay, there is one very important case law for this particular doctrine of ultravires. Let's discuss this particular case law. Now, what is the name of the case law? Ashbury Railway Carriage and Iron Company versus Riche. Versus Riche. Okay. Okay, there is this particular company called Ashbury Railway Carriage and Iron Company Limited. Okay, what are the objects of this particular company? What are the objects of this particular company? To make, sell, or lend on hire railway carriages and wagons. So it is into business of making, selling, and lending on hire the railway carriages and wagons. Basically, the the railway bogies we call. Yes, those. Okay, and to carry on business of mechanical engineers and general contractors, to carry on business of mechanical engineers, something related to mechanical engineering and general contractors. To purchase, lease, sell, and work mines. To purchase, lease, and sell, and work mines. Okay. To purchase and sell as merchants or agents or coal, timber, metals, etc. Okay. Please bother. Okay. Fine. What happened in this particular case law? Let's see. Okay. Fine. Come to the facts of the case. Come to the facts of the case. See, the directors of the company entered into a contract with Riche for financing the construction of a railway line in Belgium, and the company further ratified this act of directors by passing a special resolution. Okay, what happened here? See the objects of the company. What are the objects of the company? To make, sell, land, hire, to sell, lend on hire railway carriages, wagons, mechanical engineers, general contractors, purchase, lease, sell, workmen. Can you anywhere see something related to finance? Financing the construction of railway line, meaning to fund that construction of railway line. To provide funding for the construction of railway line, these directors have come forward. Tell me whether it is within the powers of the company, whether it is there in the objects of the company, financing. No. Yes or no? No. Okay, see. Okay, then what happened? The company further ratified this act of directors by passing a special resolution. This act of directors is ratified by shareholders by passing special resolution. It is, you only tell me, this is beyond the powers of the company, beyond the powers of its objects. Yes or no? Now this they have, what have they done? They have ratified by this act of directors by passing special resolution. It is valid? No, obviously not. Yes, the company, however, repudiated the contract as being ultravires, and Riche brought an action for damages for breach of contract. Finally, what did the company do? The company repudiated the contract. It entered into contract with Mr. Riche to finance the construction of a railway line. But finally, what did it do? It repudiated the contract. Getting it? Now, this Mr. Riche brought an action for damages for breach of. Obviously, you would have relied on this particular company for construction of that particular railway line. Now, if this company does not honor to its words, obviously this fellow went to court of law for damages for the breach of contract. Breach of contract for obviously for breaking that particular contract. Okay, his contention was that the contract was well within the meaning of the word general contractors. You can see here the word general contractors. He said this word, this whatever, the contract was well within the meaning of the word general contractors, hence within its powers. So whatever the contract it has entered into with Mr. Riche, it is well within the powers of the company because it will be covered in this particular general contractors word. Okay. Moreover, it had been ratified by the majority of the shareholders. He's also telling this is also ratified by majority of the shareholders. That was his contention in the court of law. Now let's see what did the court tell to Mr. Riche. However, it was held by the court that the contract was null and void. It was held that the contract was null and void. It said that the terms general contractors was associated with mechanical engineers. See, this general contractor should be read with this particular mechanical engineers. Yes or no? How can you tell something else? If you are giving some meaning to this particular general contractors, that is, it had to be read in connection with the company's main business. What is the main business of the company? Please read along with it. You cannot tell each and every. So next day you cannot come and tell this particular company can sell chairs. It can come and sell furniture. Yes or no? That's the same thing the court is telling. See, if the term general contractors was not so interpreted, meaning it has to be interpreted with the company's main business. It has to be interpreted with the mechanical engineers. Getting it? If it is not done so, then it would authorize the making of contracts of any kind and every description. Tomorrow it can sell furniture also. Tomorrow it can sell, say for example, insurance also, fire insurance also it can sell. It can sell tube lights. It can sell marine insurance. It can sell vehicles. Yes or no? So this general contractors is not general. General contractors is not general. It should be read with the main objects of the company. It should relate to the main objects of the company. It should relate with this particular term, mechanical engineers and general contractors. It should not be taken as a vague word giving any explanation to that particular word. Getting it? Simple, easy. Yes, ma'am. So an ultravires contract can never be made binding on the company. An ultravires contract can never be made binding on the company. It cannot become intravires by means of estoppel. Estoppel you will learn in your partnership in your Indian Contract Act. You will learn acquiescence. Acquiescence meaning what? Acquiescence meaning somewhat like how can I tell you? Acquiescence is something like giving consent. Giving consent, right? And lapse of time, delay or ratification. So an act which is ultravires to the company cannot become intravires just because of ratification, just because of giving consent, etc. Right? Getting it? Yes, if it is ultravires to the company, it remains ultravires and it is void ab initio. It is void ab initio. Getting it? What happened in this particular case? Can we see again? See, there are these directors which who entered into contract with Mr. Riche, right, for financing a construction of railway lane. Yes, this was also ratified by passing special resolution. Yes, this, and then what happened? The company repudiated the contract as it was ultravires. Now this Riche, what did he do? He went to the court of law and he filed a suit against the company for damages for the breach of contract. What was his contention for going to court? He said the contract is well within the meaning of the word general contractors and hence within the powers. Moreover, it had been ratified by majority of the shareholders. What did the court say? Court said, Riche, please go aside. Court held that the contract was null and void. It is said that the terms general contractors was associated with mechanical engineers. That is, it had to be read in connection with the company's main business and you cannot give its own explanation in general. Right? Getting it, students? Easy? Yes, ma'am. Okay, next. The whole position regarding the doctrine of ultravires can be summed up as follows. When an act is performed, which I've made you write this, okay? When an act is performed, which though legal in itself is not authorized by, it is legal. The act is not illegal, it is legal, but it is not authorized by the memorandum of association. Yes, then it is said to be ultravires the company and hence null and void. Okay, an act which is ultravires, yes, the company cannot be ratified. The company cannot ratify it even by the unanimous consent of all the shareholders. Okay. An act which is ultravires the directors but intravires the company can be ratified by the members of the company through a resolution passed at the general meeting. Good. If an act is ultravires the articles, it can be ratified by altering the articles by a special resolution at a general meeting. Good. Yes, ma'am. Okay, after we have learned all of this, children, we are done with the ultravires, doctrine of ultravires. But right now, it's very, see, I also showed you when we saw the memorandum of association of Wipro, I also showed you the amended clauses of this objects. So it's very easy to amend the memorandum of association before entering into contract if it wants to expand its scope. If it wants to expand its scope, obviously it's very easy. Just by passing one special resolution, you can alter the memorandum of association. So if a company wants to enter into a contract, it's always easy that it can amend its object clause and include that particular object which it wants to enter into, and it can easily start anything new. Right. So, however, the disadvantages of doctrine outweigh its main advantage, namely to provide protection to the shareholders and creditors. Basically, what was the advantage of this particular doctrine is that the shareholders and creditors were able to get a protection, sort of protection, because they used to know like where their money is being invested, what is it safe or not, and it is a public document, they can read through the object. All of this was there. But what happened, see, but what is it, the purpose of this doctrine has been defeated now, as now the object clause can easily be altered by just passing a special resolution of the shareholders. You also saw, I showed you that wherein this Wipro, it had amended certain object clauses. It had included new object clause. That is very easy in practical sense. So basically, this is not that important as what they are trying to tell. Yes, understood. Simple. This particular doctrine. Yes, everyone. Right. Okay. So let's stop for the day, and we will meet in the next class. Right. Thank you. Thank you so much.